So the Ninth Circuit just issued their decision in the California concealed carry ban case that myself and Reno May are plaintiffs in. This decision is kind of a mixed bag. There were some good things and some bad things, so we need to break down what just happened and then also what happens now going forward. Now, really quick before we jump into this video, I want to thank one of the main supporters of the channel, which is Blackout Coffee. Blackout Coffee has amazing coffee, and they support 2A organizations like FBC, GOA, SAF, and others, groups that help file these types of lawsuits. So if you want to get great coffee and support the 2A cause, check them out using the link down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. Now, as I mentioned in the intro, in this video, I have some important updates for everyone in California and all of us who are concealed carry holders or maybe want to be concealed carry holders. And this is in relation directly to the California SB2 law that essentially was an attempt by the state of California to ban concealed carry statewide. The Ninth Circuit has decided that the carry restrictions in places like hospitals, churches, medical facilities, public transportation, and also the catch-all private property bans, essentially the vampire rule as some people are calling it, that all of those are invalid, they're a violation of the Second Amendment, and therefore that lower court preliminary injunction will remain in place. However, like I mentioned, this was good and bad. The Ninth Circuit panel also found that the state of California can ban concealed carry at bars and restaurants that serve alcohol, playgrounds, parks, state parks, casinos, stadiums and arenas, libraries, zoos, museums, and then also parking areas that are associated with those specific sensitive locations. This was a decision that seemed very similar to what we saw the Second Circuit do with the Antioch case. That was a GOA challenge, the Gun Owners of America challenge to the Concealed Carry Improvement Act, essentially New York's new concealed carry ban. Very similar, the Second Circuit upheld some aspects of the carry ban, struck down other aspects, and then also struck down the sensitive location catch-all provision. Now, the case we're going to be talking about is the May versus Bonta case. That's the case that myself and Reno May are named plaintiffs in, along with CRPA, Gun Owners of California, GOA, and others, essentially sued the state of California because of that new SB2 law. And on review, the federal judge there, the lower court judge Cormac Carney, granted a preliminary injunction against various aspects of the CCW law in California. But remember, a preliminary injunction is simply a limited form of relief. It's just a temporary block on that aspect of the laws. That preliminary injunction that was issued by Judge Cormac Carney was then appealed up to the Ninth Circuit. It was then consolidated with some other lawsuits like the FPC lawsuit, and then also challenges to the Hawaii concealed carry bans as well that were up on appeal. So all those cases were consolidated, they were argued together in front of the Ninth Circuit, and now they have been decided together also by the Ninth Circuit. Now, on review, the Ninth Circuit found specifically to the California restrictions that applying these principles to the California statute, the panel affirmed the district court's preliminary injunction to the extent that it enjoins restrictions on firearms at hospitals and similar medical facilities, public transit, gatherings that require a permit, places of worship, financial institutions, parking areas, and similar areas connected to those places. The panel also affirmed the district court's preliminary injunction with respect to the new default rule as to private property. Now, that's an important one because that's the catch-all provision in the SB2, where essentially a business would have to put out a sign. The only option they had was to put out a sign that said, yes, you can conceal carry at this private location. Now, the Ninth Circuit panel also reversed the preliminary injunction to the extent it enjoins restrictions prohibiting firearms at bars and restaurants that serve alcohol, playgrounds, youth centers, parks, athletic areas, athletic facilities, and most real property under the control of the Department of Parks and Recreation, also the Department of Fish and Wildlife, casinos, similar gambling establishments, stadiums, arenas, public libraries, amusement parks, zoos, and museums, and then all parking areas located or connected to those areas. So like I said, the Ninth Circuit panel blocked some aspects of SB2, but found other aspects are constitutional and California can ban carry at those locations. Now, in coming to this conclusion, the Ninth Circuit panel used a looser version of Bruin, which they argue is supported by the recent Rahimi decision. This is one of those things that a lot of people are concerned about with the Rahimi decision, talking about historical analogs and using principles and concepts. Here, the Ninth Circuit is latching onto that language in Rahimi to have a broader interpretation of Bruin to uphold various restrictions. The Ninth Circuit stated that, we conclude that the proper approach for determining whether a place is sensitive is as follows. For places that have existed since the founding, it suffices for defendant, the state of California, to identify historical regulations similar in number and timeframe to the regulations that the Supreme Court cited as justification for designating other places as sensitive. For places that are newer, defendant must point to regulations that are analogous to the regulations cited by the court, taking into account that it is illogical to expect a government to regulate a place before it existed in the modern form. For both types of places, historical regulations need not be a close match to the challenged law. They need only evidence a principle underpinning our nation's historical tradition of regulating firearms in places relevantly similar to those covered by the challenged law. Even though they were using a looser approach, still Bruen is so strong that they couldn't find support for these types of just catch-all bans. Now, when it came to the catch-all vampire rule, the Ninth Circuit found that the Hawaii law that is being reviewed and the California law vary in some ways. Essentially, they upheld Hawaii's catch-all provision, but then they struck down California's. The main difference between the Hawaii and California law is that the Ninth Circuit found that the Hawaii law essentially allows businesses to not only post a sign, but also they can consent to concealed carry at their property through writing or oral consent. In contrast, California only allows permission based on the sign. And so the Ninth Circuit found that the sign-only aspect in California is too restrictive, doesn't have enough historical support, and therefore that's why they struck down that aspect of California's catch-all provision. Now, one of the concerning things also with that is almost they're signaling that the Hawaii one is valid, and so it wouldn't really take much for California to then modify their statute to just mirror Hawaii's, and then it would pass constitutional muster according to the Ninth Circuit. Now, also interesting in this opinion is the fact that the Ninth Circuit rejected the government kind of in loco parentis argument that was being brought. This was also referenced by Justice Thomas and Bruen, where if a state or the federal government wants to make an area a gun-free zone or a sensitive location, well, then the onus is on the government to provide protection to those individuals. And the argument is, unless the government does that, then they cannot ban that specific area. And if there is a sensitive location, they have to provide that type of protection. But here, the Ninth Circuit is rejecting that. They're saying, no, just because an area is a sensitive location doesn't mean that the government has to give you protection. Now, also interesting is the Ninth Circuit rejected the state of California and the other government arguments that any sensitive location tied to a protected class of people is okay. What California and some of these other governments want to do is say that it's not specific about an area, but maybe it's tied to protected classes or more vulnerable classes like children and other people. But the Ninth Circuit rejects that, says, no, that's dumb. We're not going to do that, because that would mean essentially anywhere, any location tied to children would be off limits to concealed carry, and that's just not true. Now, when it came to the specific bans like places of worship, the Ninth Circuit actually did find that those locations clearly existed at the time of our founding, and they could not find a single historical law or analog that would support a statewide outright ban on concealed carrying at those locations. That shows even more so how strong Bruen is, even though a looser analysis is being used by the Ninth Circuit. Now, I do want to note that the Ninth Circuit did find that still, individual property owners, churches, and other areas could on their own still ban concealed carry. They could say, hey, our property is off limits for concealed carry, but it is not okay for the state of California at large to mandate concealed carry bans. That type of right is left on the property owner if they want to do that. So you may be asking, okay, what happens now? Well, the attorneys for the plaintiffs here have stated that now they are deciding whether or not they want to seek en banc panel review in the Ninth Circuit, if they want to go directly to the Supreme Court, because that's an option as well, or they can simply kind of take the half win that they have right now and go back down to the lower court and seek to resolve this case on a final merits. Now, this is one of those things that's up for debate. Every attorney has different perspectives right now on what these 2A cases should do. This is one of those ones where I do think it's better to move this towards a final merits decision, but I don't really think it's necessarily an either or. I know when you look at other cases like out of the Fifth Circuit challenging the ATF's pistol brace ban, you had the organizations there that not only sought appeals of the preliminary injunctions, went Fifth Circuit, en banc panel review, and took them up to a higher level, but at the same time, they also moved the lower court case towards a final merits decision. They also did that out in Illinois. So I don't think it's an either or case. Sometimes maybe it just comes down to resources, but I think this is one of those cases where I think it's kind of both. The greater implications of this is the fact that the preliminary injunctions are going to be removed. So the mechanism going forward in the Ninth Circuit might actually be seeking a stay to keep all of SB2 halted, because again, that has real world implications for concealed carry holders like me and others. Because if you just wave your hand, say, nope, we're not going to appeal this, go back down to lower court, well, then that means half of SB2 can be enforced by the state of California. So that's what's happening right now in the California concealed carry ban case and the Hawaii concealed carry ban case. So again, if anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.